Good evening and happy Wednesday, everybody. Welcome to the Health and Human Services Committee meeting. Today is Wednesday, October 2nd, 2024. If anybody else is surprised that it's already October, I will join you in that surprise. Tonight we just have one agenda item to talk about, and I'm very excited about it. It's been a long time in the works. In April of 2022, Councilmember Fossey made a motion to work on some tenant protections, and I was the second on that motion. Since then, we've been working with folks from the Housing Justice Project at the Snohomish County Legal Services team to put together a draft ordinance. In the meantime, we did receive a memo from Jennifer in her previous role here at the city about ways that we could incorporate some different tenant protections. And then there was also a memo that we had received from David Hall about a previous effort that had taken place in 2009. Long time ago. He was still on the memo though, which I was glad to see David's name still there from 2009. But that effort sounded like it got a little bit of traction, but then there were some questions and the process just sort of died on the vine. So this effort is a rejuvenation of those efforts. And since 2009, there's been a number of other jurisdictions across the state that have put in a rental registry program and tenant protections. And so these ordinances are modeled after the work that they've done and success stories that they successes and lessons learned that they have had as well. The ordinances that we have are everything from Toppenish to Tacoma and Sunnyside to Seattle. So there's was a lot of reading involved, which was great just to help get a holistic view of what types of policies do work and which ones are maybe too burdensome on the system. So I think, let's see. When we did start working on putting the tenant protection ordinance together, we came up with an initial draft, and then the question came up of, how do we let landlords know about these new requirements? Like, what type of Rolodex is out there that we could use? And so that's when we shifted to also including the rental registry ordinance to make sure that we had an accurate list of qualifying landlords out there where the tenant protection ordinance and policies would apply to. So there are exceptions to both the rental registry and to the tenant protections. Mainly, if a person is renting a bedroom in their house or they're on site, then they would be exempt from both of these ordinances, and there's other exemptions as well. So the intent was to provide flexibility and not to have too much pressure on small-time landlords to fulfill burdensome government requirements. So these drafts are our initial drafts that we're ready to pass along to legal and to administration to take a review. And the intent is that we would work collaboratively after this to put together the next another draft ordinance that would come back to council for deliberation review on whatever timeline might be coming down the pike, knowing it's budget season and there's plenty of work and other documents to read. So at this point, I wanted to kick it over to folks from the Housing Justice Project and Snohomish County Legal Services to just help with teeing it up and walking us through the two different ordinances and what the different policies are and applicabilities, and just to give like an outline of what it is, and then we can also answer questions and just talk through things as well. So I'm not sure if you wanted to start with the registry or if it makes more sense to start with the tenant protections portion, but I will leave that up to you for whatever order you already have your talking points drafted in. And if you could, unmute yourself and introduce share your name and title just for the record for folks listening, that'd be great.
Thank you for having us this evening. Thank you, Councilmember Ryan. I believe you're chair this evening. Chair? Does that change okay, sorry. Jane Pack from Snohomish County Legal Services. I'm the executive director, and this evening with me I have Victoria. If you can introduce yourself, Victoria.
Victoria Heitman. I am the HJP lead staff attorney with the Snohomish County Legal Services Office. I've been with the organization since 2019 as a volunteer, and we've been with the program through all of the changes and moratoriums and changes to the tenant rights through all of the state of Washington. Mm-hmm.
So thank you for giving just a great overview of what we'll be discussing this evening, and we will outline our rental registry program proposal and our tenant ordinance this evening, and we will also allow time for questions. So we will, before we get into, let's start with the Everett tenant protections, but before we get into it, Victoria did bring up a great intro. So a little bit about Snohomish County Legal Services and how we did come to the table and the position. So Snohomish County Legal Services is a nonprofit legal aid organization, and our work with housing, we do provide housing services in a broad spectrum. We are a tenant advocacy agency, but our work, so Snohomish County Legal Services houses the Housing Justice Project program. We've been in operation since the 1980s, and we provide our services through the Housing Justice Project program. We have a courthouse clinic, and with the implementation of the Right to Counsel program, our agency was one of the agencies, service provider for Snohomish County that implemented the Right to Counsel program, and we seat 5 out of 7 allocated attorneys that provide court-appointed representation in eviction defense, and it's colloquially referred to as right to counsel for eviction defense, and that's if low-income tenants are facing eviction, then they have a right to an attorney to represent them in their eviction defense, and our agency houses 5 out of the 7 allocated attorneys for the county. And lastly, throughout the pandemic, we were also involved and collaborated with the Volunteer of America in Dispute Resolution Center in the Eviction Resolution Pilot Program. So we collaborated with the VOA DRC, the Dispute Resolution Center, in implementing this mediation with repayment plans and just giving an additional opportunity to essentially an eviction diversion program so that we can resolve cases and settle disputes before it gets to an eviction case in court. And a little bit about how evictions work is when an eviction case gets filed, it's out there. There are things that we can do to limit the information getting out there, but the harm and the impact is irreparable. So all of those upstream preventative measures, in our experience with all 3 of those programs, have made a huge impact in our clients' lives and a relief on the systems and the systems process and the judicial process. And with our experience in all 3 of those programs, it helped inform us as we were looking through all of the different sample or model example ordinances and rental registries out there. We pulled components and then took some components from the Eviction Resolution Pilot Program and some of those tenant protections that, because we had the hands-on experience, we really did see that it made a difference in our clients, the resolution of the case, the success of their case, and just helping them recover from the pandemic and just give them just a little bit more dignity and humanity in just in a crisis situation.
Can I just add a couple of points here as well? So the Eviction Resolution Pilot Program first launched in about, I believe it was 6 counties. We were one of the first counties in all of Washington to implement that here, and that was fall of 2020. So a lot of the items inside this ordinance pulled from that program for the tenant rights protections. And then the right to counsel that Jane was talking about, to have an attorney be present for the through the eviction process, that began in all of Washington May of 2021. And then the program with the attorneys began in Snohomish County in September. It took a while to get it implemented and launched, and that was when we were able to provide those attorneys, was in the fall of 2021.
Thank you, Victoria. That was a really great follow-up. And with the eviction resolution pilot program, it did sunset in June of 2023. So with that, there were things that worked and things that didn't work, and that's where we came in and we pulled some of those things as inspiration. And looking into we're going to go into the ordinance first, and then we're going to go into the rental registry. But we did incorporate, looked at the different various, the building codes, the international building code and the international residential code, in addition to our local codes, and looking at different ordinances and rental registries of surrounding cities and municipalities, and just making an informed and pulling examples that would, Snohomish County is it's very unique. So we wanted to pull components that really complemented the county. So we did look at several different things. And even though we are a tenant advocacy firm, we were mindful of some of the proposals and some of the components that we pulled in this proposal, so that it is something that that is practical, that will work for the county, with an overall perspective on tenant protection and how some of these policies can increase housing stability, because a lot of our work is keeping people housed, those that are housed, to keep them housed, in addition to if in the event that they do have to move on, that they have the resources and the ability to have that housing mobility. Because with the lack of housing inventory and just the market, some of these, it's easier to keep people housed than trying to get them into new places. So that's kind of a high level of where we were coming at when we pulled some of these samples to put together what we are proposing this evening. Okay, I think I kept switching back and forth, but we're going to start with the Everett tenant protections. So as I said, we were balancing the interests of tenants and landlords. We do routinely, we are in court, so we hear, we're aware of the issues and the concerns of both parties. So just trying to balance that in a way that it's a workable situation for both sides. The landlord-tenant relationship is a little bit unique, where it is a business relationship, but there is some personal components where if the landlord and the tenant aren't able to get along, then there may be a breakdown that doesn't make that relationship work. So those are things that we work at with our Housing Justice Project program and our housing department, to try to work through some of those issues and resolve some of those maybe communications or relationship breakdown barriers. So shall we go into the executive summary? Would that be easiest? Okay. So that is the purpose and intent of the model ordinance. And with the other big component is getting the information out to the public. And we believe that that is a win-win for landlord and tenants, because we find that with access to legal services and being able to advise and inform tenants of their rights, it makes them better prepared, not just of their rights, but the expectations, and that they are able to make informed decisions. So we are big advocates of education and outreach, and that is a large component of the work that we do, is informing our county and our tenants of their rights. And with that as well is with landlords. Sometimes landlords don't know what their obligations are, or we're seeing an increase in maybe mom and pop landlord coming into court trying to navigate the system on their own and maybe not knowing the process as well. And because we are tenant advocates, we do try to provide education and outreach to the community as a whole in general, but we are tenant advocates as well. So where we are able to educate the general public, we do make that effort. So we're asking for an informational packet. That was a large component of the eviction resolution pilot program, where there was a notice that a resource of legal resources and about the different programs out there that was sent out, and Victoria can explain better, so I'll hand it off to Victoria to explain the informational flyer in the ERP program and what we are proposing.
So the informational packet, well, with the eviction resolution pilot program, it was geared towards non-payment of rent, unpaid rent cases. And so when a tenant received a pay or vacate notice, the landlord was required to give what was called the ERPP notice. On that notice, it had resources, which we found was a vital step to getting those people getting the tenants informed of what resources are out there, such as rental assistance, legal aid, and other resources on that information as far as where to go for mediations or how to communicate with the landlord and getting that support through the Volunteers of America Dispute Resolution Center. And so with this information packet, it would be a helpful resource so the tenant already knows kind of where to go, especially when they get into a situation and they need some direction of where to go. And then also for the landlord just to be aware of what there is, because if there is rental assistance out there, they would be interested in receiving that rental assistance to become whole again. And because of the ERPP program that has been here in Snohomish County, 2020 through to July 1st of 2023, it's been a practice, so people are familiar with what that sort of document would look like and what that resource would look like. So this is a low burden and barrier on a landlord to supply that super simple informational document along with their tenant rental lease, I believe is what it would go with.
Great, thank you. And I just wanted to add too that in the memo from Jennifer, there was a mention of a recommendation for having a resource website for renters to help them with collecting resources and programs with Snohomish County. So this would fulfill that recommendation too, of making sure that tenants have resource information ahead of time before they get to potentially get to any sort of a sticky situation. So check that box.
And it also makes sense that it would be housed with the city because it is where landlord and tenants, it's a place where they know where to look for additional information in the event that they need it, because that's what we're seeing is, that's what we've seen is when they do need those services, if they already know where to look, it makes a huge difference. And that's why we do so much outreach, because they may not need it today, but when they need it, they'll know where to find it. And just to house it with the city just makes so much sense. And so that's where we are proposing that this information and resource packet be housed. Should we go by the numbers, or should we refer to it as numbers?
Yeah, 3.
Okay. So with number 3, we are proposing that additional information be required with the notice, in addition to resources in plain language, so that tenants and landlords can understand their rights and obligations. Within our proposal, what we've found with the ERPP program is when there was a sample language, and we kind of mirrored some of that sample language in our proposal of what a notice would look like, so that it takes the guesswork from the tenants or the landlord in what do I need to provide. So we have proposed sample language that we pulled from our experience with the eviction resolution pilot program.
And if you want to put out there on the record, so if they're looking at the draft, it would be page 9 has that notice of tenant resources, which you could see has, basic, just super simple information about where to get those resources.
And that's subsection 4.2. So it can just be copied and pasted directly into their written notice. So for number 4, we propose a reasonable accommodation for tenants with limited English proficiency. So we understand that a lot of our clients and a lot of we're speaking to our clients that we serve and are low income and come from historically marginalized communities, but they're also exacerbated by language barriers or other barriers that impact their ability to access services. So one of the things that we're seeing is that notices are in English, and we do serve a large portion of the community that don't speak English, or their understanding of English, their English proficiency is limited. So that does impact their ability to access and understand their legal rights. So we're asking that just for notices, particularly notices that have such a huge impact on their housing situation, or that may impact, maybe a notice to terminate their residency, be in a language that they can understand, so that they can correct or try to resolve the issue, or just have a basic understanding of what the issue is, so that they can stay housed.
And generally, the landlord would know when they're speaking with the tenant or whoever they're renting to that there may seem to be a language barrier here. And so for them to be successful in getting what they want as well, that person would need to, it would be helpful if that person knew what that issue was in the language that they can understand.
And some of our proposals are proposals that, in our experience, we've found that bridges the communication between the landlord and the tenant, or that facilitate communication, because the reason why we bring up the eviction resolution pilot program, the biggest thing that we saw from it is requiring a repayment plan, or requiring mediation or a meeting. Maybe it didn't resolve the issue, or maybe it did, but opening the door to that communication made a huge difference in the parties coming together and trying to resolve that. And that was, I believe, one of the biggest benefits that we saw from that program, was just that opportunity for the parties to come together to resolve their issues. And with landlord and tenants, trying to put that breakdown of communication, or that breakdown of the relationship, back together. And sometimes we would assist with that. And communication, being able to communicate with each other, plays a huge part of that.
Which brings us to number 5 of the repayment plan, and meeting to discuss the payment plan. So what Jane was just talking about, this is where we had grabbed from the eviction resolution pilot program. That was the whole point, was to try to help the non-payment of rent, get some payments started and going, especially because of unforeseeable circumstances that led to that individual being unable to pay their rent. And so what we've implemented in here was the similar language that was brought through the ERPP program. For example, like what is considered a reasonable payment plan? 1/3 of the rent on there would be considered a reasonable plan to offer. You know, it would be a little unreasonable if the landlord was asking you to pay 3 months of rent on the same month, and let's try to spread out that back payment over time to make the landlord whole again. As far as what we've learned through the ERPP program and having a meeting with the parties, what is developed in this drafted part is you don't need to go through a middleman. You don't need to go through Volunteers of America to schedule that meeting, to have that conversation. What's drafted in here is a landlord proposing different times and days to have that meeting and conversation, and then the tenant responding and the two parties coming together to talk about some sort of payment plan. So through the ERPP program, because there was so many tenants facing the hardship of being able to pay rent, there was a little bit of a backlog to try to get that meeting scheduled, and that's what we've learned why this proposal is more reasonable and less burdensome for the landlords and the tenants to come together and not have to wait to get that meeting scheduled from another party or entity.
And what we've seen with the repayment plan and our proposal and the client that we serve in our community is that the majority of our cases have a basis for non-payment of rent. People can't afford basic housing in the county, in the state, and this is an additional opportunity to keep them housed where they are housed. And I don't know that, how many people willingly don't pay their rent. I believe a lot of people want to pay their rent. They want the opportunity. And with a repayment plan, they have every intention to pay back what they owe. They just need a little time because maybe they lost their job or whatever it is. But it is an opportunity to stay housed, and an opportunity to catch up and stay housed. And this proposal is an opportunity to discuss a payment plan and open up that opportunity that we've seen makes a huge difference.
I do want to add on to this repayment plan a little bit here that it would be in the landlord's best interest not to wait for a lot of months to accrue, because they probably wouldn't like a payment plan that might last longer than what they're expecting. So it might not be a good idea to wait 6 months of unpaid rent and then trying to, having to offer a reasonable repayment plan to 1/3 of the monthly rent could extend quite significantly, maybe over a year to pay that back. So it would be ideal for the landlord to just keep track of that and keep that in mind. And this informational packet and educating the landlord about this and this ordinance would be helpful for them to know that.
And we also saw, and I won't say this generally, Victoria is in court more, so she has more experience, but we've also seen that sometimes even when a tenant is able to pay back a substantial amount of money, maybe they receive rental assistance or whatever it is, they don't get that opportunity. So this gives them an opportunity to work something out and say, I have the funds to pay this back. Will you accept it? Or let's work something out. I'm only a little bit behind. Or it's an additional opportunity to resolve their issues before an eviction filing. Okay, and segueing into number 6 is a notice of rent increase. And a lot of our, not just our clients that are low income that qualify for our services, but just the community that we live in, a lot of their income is fixed. So when you get an increase, you're relying, you plan, or our elderly community, or those that receive a fixed support or a pension or retirement plan, they live on fixed income. And to not get enough notice when you're relying on your set income coming in and the expectation that you're going to have to plan out this much for rent each month places a huge burden when you don't receive as much notice so that you can plan forward and make adjustments. That makes a huge difference for our clients in particular. So we're not proposing that there be no increase. We're asking that there be more accommodations at this time and that there be more notice and time so that people can make those adjustments, and those that are most vulnerable, low income or on a fixed income or disability income, retirement income.
And just to add, so the current state law is 60 days but to provide that notice for rental increase. And so in this proposal, it's 120 days if the increase is going to be for 3% of the monthly rental amount for a year-long period of time, or a 180-day notice if the rental increase is going to be 10% or greater, given that much time. And so generally, oftentimes, rental agreements are year to year. And so generally landlords do increase the rent when the next year comes up, because things change, taxes and whatnot. And so this would just be something that a landlord would want to just keep track of and put it on their calendar. So that way, if they are planning or intending to increase the rent, that this is doable. And I will also say that this ordinance is implemented already in another county, in King County, Kenmore, I believe, and that one is still enacted or implemented.
And number 7 is rent increase, which causes economic displacement for low-income households. And before I pass it along to Victoria to add any information about rental increase, I do want to specifically point out, I believe I mentioned it in a previous presentation, that Snohomish County is a hotspot for evictions and displacement as people are moving up into the county, and that's why it is so important to have these heightened local protections. Surrounding cities and municipalities have implemented various ordinances, and we have no, as far as I'm concerned, we have no local ones, and I've checked, and I don't believe we have any at this point. So it was called out in a study by national Pulitzer Prize author Matthew Desmond, and it was in a recent study that he published that called out Snohomish County with various hotspots for eviction and just being an area for displacement.
And this is kind of something landlords are somewhat currently doing in a way, doing agreements such as cash for keys, because they want to get another tenant in there. They want somebody else that might be able to pay more. So it's somewhat what landlords are sort of doing in a different way to get another tenant in there.
I'd like to take a pause before we get into habitability, and I I guess I should have put this in the beginning, but default rates, that's for eviction cases, are about 50% throughout the state. But there is a study that Snohomish County Legal Services has been involved in that has not come out, but we are, maybe by a fraction of a percent, but we are the highest county with default rates. That's when, you just go to court and what's a good way to describe default? Like you just lose or it's not contested.
Yeah, so default is when there's kind of not a response or a no-show to a hearing, so they missed the whole opportunity there, and the landlord generally, or their lawyer generally gets that default, gets that automatic grant of that unlawful detainer action against the tenant. And so as far as kind of what this looks like, so oftentimes here in Snohomish County, a tenant is served with a summons and a complaint. On both of those documents, they're unfiled sometimes because it's cheaper to pay to get a default than it is to file it. And sometimes they also don't have to schedule a hearing to go. They can go ex parte the very next day after that deadline date if there's no response. So a landlord can prevail and it can be quick because the person didn't respond. Versus if a person did respond, then they would be required to file it, set a hearing, notify that tenant about that hearing. So it takes a little bit longer before the landlord is able to remove the tenant from the property.
I also wanted to add real quick that the rent increase causing economic displacement is also in line with one of the recommendations from Jennifer's memo about tenant relocation assistance. So I just wanted to call that out. And I also wanted to give a friendly reminder about time. I know we also have the rental registry to get to, so I know we've got a few more numbers to get to here as well. So just wanted to bring attention to that.
Thank you for that reminder. I think I told y'all last time not to give me a microphone, but so I did look at some of the data and just going back to pointing out some high level, and we can skim along because I know that we do have some things that we want to draw out with the rental registry. So 211 is the statewide hotline for resources, and just checking as of today, Everett still consistently so, but I for sure checked it today, so I know that two of Everett's zip codes make up two of the top 10 for the entire state for housing resources and requests. So people are calling in asking for housing resources, and Everett zip code is two of Everett zip codes make the top 10 out of the entire state.
So I'll take over this rest of the part here because a lot of this stuff, the remainder of what is drafted, is actually already implemented under the RCW 5918 Residential Landlord Tenant Act as far as the duty to keep the unit up to code, keep it habitable for a tenant to reside there, moving in fees as well, doing a payment plan on that to pay that off. That's already implemented. With regards to the date of rent payment, there is a Fair Housing Act that generally what happens here is oftentimes a person doesn't get their Social Security income until a later date in the month. And so this is where a tenant can ask for that reasonable accommodation to change the date of, instead of the first part of the month, to move it to another date where they do get their income to be able to pay. And so that would essentially be a violation of the Fair Housing Act if the landlord wasn't able to accommodate that request. It's a reasonable request. So it's already kind of implemented as far as tenant rights. Same with a Social Security number and not being required to do that in order to rent, as well as there shouldn't be any waivers of tenant rights within that rental agreement as well. And that there could be some sort of liability or penalization if there is a violation of any kind of state or local city ordinances. So if we want to, if there was anything else you all may have seen on here that you'd like to highlight before we move on to the registration.
Good. Council members? Great.
And going over the summary, we did pull out for the, what do we call the collective group of the city council? Areas that may have been a little bit different or that we might have pulled from different areas. So we did highlight those areas. And then for the record, RCW is the Revised Code of Washington statute. Okay, so let's get into the rental registry program. There are lots of policy considerations, and I believe that y'all may already have a memo that goes over a lot of the policy considerations. But for us, it's looking at, again, the balance of information and just the issues, overall, generally the issues that we see. So just to touch on, so even though we represent clients that are evicted in court, it's only the tip of the iceberg. So we handle a lot of housing issues and resolve a lot of housing issues before and if it gets to the court process, the judicial process. And a lot of those issues are reasonable accommodation or discrimination or repairs disputes, things that we can try to resolve and settle ahead of time as well. So those just coming into that. And that's teeing up for the rental registry program. That is the goal is just to provide safe housing for our clients. A lot of our clients, well, I wouldn't say a lot, but we do see clients come in, oh, sorry, I wouldn't say a lot, but I wouldn't say not a lot, sorry. Our clients, we see that, you know, they're living in houses that are uninhabitable, that are not meant for habitation, that have no plumbing, that have no heat, that have no water, living in cars. So that is what we see on a daily basis. So that is kind of the lens that we're looking at with the rental registry program is how can we make our housing safe for our community.
I will also add that it's already a requirement anyway as a landlord duty is to provide habitable space, to provide these necessary things. It's also very important for the community too, the neighborhood, the neighbors. If you have a home with electrical issues that could spark fire and then lead over into the neighbors. So it's important for just everybody, not just the tenants, for this safe, stable home. And the landlord could be penalized too and impacted by, you know, potential lawsuits from the neighbor or whoever else they may have harmed, not just whatever happened to the tenant.
And the rental registry is a way to collect that information and to track it in a more, I guess, transparent way. A lot of our data is collected through our cases and we share the information, but it's cases that come through our doors and it's not necessarily we can't track the housing supply and those kind of different things, but to be able to see where our housing market is and the supply at any given time also informs policy decisions in terms of like how many homes need to be repaired or are not inhabitable, or what vacancy or even housing supply that we have.
The other big component about this as well is there are tenant protections, right, to have a safe, stable, habitable home, but where this statute falls is the ability for a tenant to get relief or to file a complaint anywhere. It's really difficult for a tenant to do that if there's not a system or a platform for them to go and have somebody be able to do that. Oftentimes, they're faced with, you're not the owner is the one that needs to contact us, or, and this would be a helpful resource for both parties to be able to communicate and find out, for the landlord to know, well, what am I supposed to do? What is this home supposed to look like? And to have that, the checklist along with this rental registry program.
To add on to what Victoria was saying, it streamlines the process, but also houses the information for landlord and tenants in one place so that tenants and landlord can be informed of their rights and obligation. A lot of our outreach, we do a lot of outreach and getting the word out, but to be able to house this information in a central streamlined place would be ensures that the information gets into the hands of those that want it and need it in a proactive way, in a way that they can find it when they need it, so that they're not looking for different places or relying on, attending an outreach event or those kind of, it's more upstream.
It would also be really just helpful to educate too by having that contact information that you can easily send, an update or a notice or changes to people that are landlords that are currently renting. So that way they can just be on top of the new changes and be educated to what might be happening statewide or even locally as well. So just having that list, an available list for the city to have access to so we can educate them of those changes.
Yes, to add on to what Victoria was saying as well, it's distribution of services and resources. So with the eviction resolution pilot program, when we were involved in mediation or settlements, we were finding that some of the hesitation with negotiating or coming into a mediation was just a lack of knowledge, where maybe a landlord wasn't represented and they didn't know that there were resources out there or why, or the benefits of coming to an agreement. And it was once they got into the mediation and they were informed of maybe this landlord mitigation fund or rental assistance or these other resources that really helped to settle the dispute.
Yeah, I think it'd be helpful if you could walk through the applicability for the rental registry program.
Okay, so we're proposing that there is a declaration of compliance checklist, and this is pretty basic. It is a self-inspection checklist per property, and we have provided a sample that the city can use to jump off on. But it is, at this point, it is a self-inspection declaration as to the habitability, which is a basic standard for housing. Like, you want your housing to be habitable. And we're proposing that it be housed on a portal online where it's easy to find with the city, if that is possible, because that would be the most logical place for people to look for resources when they are looking for anything relating to their housing. It makes sense to house it in one place. And we propose that in order for there to be compliance and for accountability, that there be violations and penalties that would be tied to trying to rent out homes that are uninhabitable. And the definition that we use for uninhabitability is defined by the Washington Revised Code of Washington. So that is by statute the definition of uninhabitable.
So this would be applying to all rental dwelling units, short-term and long-term rentals, with the exception of rooms for rent, transient guest lodging, hospice, hospitals, community facilities, governed by the government and agency or authority who owns those. Generally, they have specific requirements and things that they do to be able to house certain people, and they have their own standards they have to meet. Or also emergency temporary shelter. So this wouldn't apply to those types of housings.
And what we're proposing is an annual registration. We've looked at several samples and proposing an annual registration because of some of the different factors of some of the exceptions that, so the registration would be transferable if the property sells, it would be transferable for that year. And it's very low barrier what's being proposed in terms of what the landlord must do. It is a self declaration. And I believe, let me see, that if the unit is inspected every 3 years, then there is an exception to that. I can't find that, but let me look at that, see if I can find that. And any fees related to the registration will be set by the city, whether they want to do a tiered or create exceptions for housing providers that provide low-income housing, those kind of situations.
It definitely would require some sort of fee or payment, so that way it can pay for the administrative staff who will have to update and keep track of these or of this registry. So that's why the fee is needed to have. And we're anticipating that it would be a minimum type of fee, and we're not asking for that it to be too extreme and burdensome and a financial barrier for a landlord to pay.
Great, thank you. Thanks for that reminder too. Yeah, and I'll add too that the self-certification isn't, also has like a check and balance on it where their tenants do have a route to make a complaint with the city to ask for an actual inspection if they feel like their space isn't habitable, but their landlord registered that it was. They can report to the city to share circumstances or pictures or something along those lines to have an actual inspection happen to make sure that the landlord brings their space back up to code. There's one other.
And I believe the inspector was going to be like a qualified inspector, somebody that is knowledgeable and understands what would be code and habitable. And so I believe there would be like a list provided of potential options to be able to do that.
Right. And then the ordinance is also open-ended on what that registration fee would be and how it's calculated. So that's a decision point that we wanted to open up to full council of if it's per unit, if it's like a minimum number of units to trigger it, if there's a cap on it, and just how it's calculated as well. So that's nothing that's been defined at this point, and that's will be part of the ongoing conversation. So I see that we are 1 minute over. Are there any last burning things that you wanted to add? Or any questions from council members?
Lastly, with the rental registry process, there have been rental registries that have been implemented around the country, and there is a high participation rate. So from Minnesota, they've had their rental registry for about 10 years, and they are at 90% of tracking the city's rental properties. And some of the other cities that have been a little bit longer are, there's Concord, California is at 73%, and Portland has a successful rental registry at 75% of the city's property owners. So it works.
Thank you. Appreciate that. Last questions from council members? Great. Yeah, thank you, Jane and Victoria, so much and Adam too. I know he's out on paternity leave, and your whole team for your great work on this. I know during the Proposition 1 discussions, there was concerns about voter protections for our tenants, and I feel like what's here is some great starting blocks to help with those bumpers on the bowling alley to make sure that our tenants are protected, and just to help with balancing out that power between landlord and tenant dynamic. So thank you again so much for being here tonight, and with that, it is 6:01 and we are adjourned. Thank you.